A curious old principle of common law says that once a defendant is sentenced to prison, the sentence begins to run and continues until the sentence is complete, regardless of whether the prisoner is actually in prison or not, and even if they escape. New South Wales in 1924 passed legislation to overturn this principle, but Parliament did not do so the simple way by declaring that time didn't run during the period while the prisoner was at large. Instead, the provision stated that upon their recapture, the prisoner would have to serve an additional sentence equivalent to the period of time they'd been on the run. Gibbs was a prisoner who escaped and was then recaptured. He argued that his parole eligibility date should not be affected by his escape. He argued that his accrued entitlements to parole or probation should be preserved. To consider this, the court had to construe the 1924 statutory provision, even though in 1924 there was no system of parole or probation. How then could the court work out the intention of the Parliament? It's a basic principle of modern statutory interpretation that courts are to take a purposive approach. They are to work out the intention of the Parliament and to give effect to that intention. However, Parliament is not a monolithic body with a single intention. It is composed of parliamentarians who may be bitterly opposed to one another, or who may vote in favour of a piece of legislation for any number of different reasons. How is it possible to determine a parliamentary intention when no such thing might exist? President Kirby said, "It is often said that courts in construing legislation are ascertaining the intention of Parliament. This does not mean the intention which the legislators sitting in Parliament subjectively held when the statute was enacted." Instead, he said, citing earlier English authority, that one should look at the objective intention which arises from the words of the Parliament. This risks being circular because we use the words of the Parliament to identify the objective intention, which we then use to interpret the words of the Parliament. However, it remains a key principle of statutory interpretation that statute is to be interpreted according to parliamentary intention, which means the objective intention of the whole Parliament and not the subjective intention of any member within it.